Here's why. He was already out on bond when he fled from 2 Pennsylvania state troopers and endangered them and assaulted them, and he was locked up again. And this is Judge Xander Orenstein, okay? This guy was hearing what we call in Florida first appearance. Even though this guy is already out on bond for criminal charges and is facing more felonies, this goober smoocher let him go without posting a bond.
The state of Michigan versus Deshaun Thompson, case 24044900301. Today is the date set for.
Okay, this SovCit was just on. I did a whole video on him. I put a link to it in the description below, but I'm going to interrupt this and give you 30 seconds of the prior appearance for reference for people who haven't seen it. Let's do this.
Mr. Reagan?
Yes, I'm just saying, Mr. Thompson does not want to give his full name. I know that we have a complaint here as John Thompson for refusal to fingerprint. He's refusing to fingerprint. That's why we are before this honorable court this morning.
Yes, that's against my constitutional right, though. I don't have to do that. I don't have to enter into a contract. I don't have a legal name. I don't have a legal name with the state. That's against my constitutional right. All statutes are not law.
We've heard you enough, sir. We've heard.
Bond redetermination hearing. Appearances, please.
Okay, that was the last hearing. Now we're to today. This is ultimately frustrating, but it's still funny.
Please.
Morning, Your Honor. Samuel A. Ragnone, P23-157 on behalf of the meeting.
Good morning, Your Honor. Jessica Shine, P number 81798 on behalf of Mr. Thompson. Mr. Thompson, please state your full name for the record.
Under duress, my full name is Deshaun Thompson.
All right. Thank you, Mr. Thompson. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable at $100,000 cash or surety. Ms. Scheib, as to bond.
As to bond, I believe this bond is very excessive. This is a misdemeanor, allegedly refusing to get fingerprinted. To my knowledge, no criminal history, not on probation, parole, nothing pending, lifelong resident. This is non-assaultive. Respectfully asking the court to consider a personal bond. Unless I'm missing something here, I don't know why a bond this high on a charge like this.
Okay. Mr. Ragnar?
Your Honor, we think the bond is appropriate and we're asking for it to remain in place. If the defendant was able to walk out of jail without providing his fingerprints in the charge, that would not fit well with other charges that he had pending or future charges that he had. And he does have convictions, Your Honor, back in 1031-13, interfering with a police officer and malicious destruction of property, $200 to $1,000. 62014 police assault, resisting and obstructing. He had a drug charge also. In 3719, pled guilty to police assault, resisting and obstructing. Was discharged from Michigan Department of Corrections on 9/13/21. He had a sentence on 22620 for police assault, resisting and obstructing. And sentence 3, he had a attempt controlled substance, 25 grams or less, discharge 5/9/19. He's got a history. He's got an assaultive history. I think 3 assaulting and resisting matters. And we're asking that the bond remain in place.
Yeah, may I respond very briefly?
No. All right. I'm going to set bond at $100,000 personal. Mr. Thompson, your next date is going to be July 29th, 2024, before Judge Bryant, I am going to remove the tether requirement. Mr. Thompson, excuse me, July 29th, 2024, before Judge Thomas. Strike that, before Judge Bryant. You're going to get paperwork with that information on there. Sir, I would suggest that you signed up for text reminders or email reminders if you want to make.
Mark your calendars. This guy appearing in front of Judge Bryant should be fun.
Sure you make that date. Do you understand?
Okay. Is this a court of record?
I'm sorry?
Is this a court of record?
It is.
Okay. You judge who again?
I'm Judge Williams.
Judge Williams. And what judge am I?
Judge Williams, do you already feel stupid for giving him a PR bond? I bet you're reconsidering that right now.
CNX on the 29th?
Judge Bryant.
Okay.
All right. Then that concludes this hearing.
Thank you, Your Honor.
You're welcome.
Do I have at least 2 witnesses that they are committing treason? This is treason. They're violating my rights.
Mr. Asper, turn on your video. We'll get started. All right. Very good.
Oh, there you go. Sorry.
Okay. On the record, State of Michigan versus William Asper, 2300546 SM. And you are William Asper joining me by video. Is that right?
Good morning, Your Honor. Yes, William Asper, defendant. Well,
Right.
case, yes.
All right. Mr. Asper, you're here for a show cause hearing. Back in May of 2024, you were released from your probation, but you still had a balance of fines and costs. And it's my understanding we need to set up a payment plan on that. Is there a payment plan that you believe would be adequate that you could afford to stick to?
So, good morning, Your Honor. So I had spoken to, I'm not sure what office it was. I don't believe I have any funds to make any sort of payment plans. As I think I said to the court, I am a trustee of an account. I have to pay mortgages, and every month that account, because of repairs and whatnot of properties, has been in the negative. So I don't have any access to put towards this. As well as what I told the clerk is, since back then, I have a son now who was born with some a genetic condition. I'll put it. And I mean, it takes my time up. Obviously, there's more money involved, but I don't have any ability to make any payments, Your Honor.
So you need to provide to the court adequate proof of your income and debts in order to prove that you do not have the ability to pay. Otherwise, I do have to continue to attempt to collect this money. What I'm willing to do today is to adjourn this a month to give you time to collect your documents and or consider what payment arrangement you can afford.
Okay, so Your Honor, I have my trustee thing, but I don't take an income from it. So as far as income coming in, I don't have any. So it's zero right off the board.
If you're not disabled and unable to work, then you have the ability to work and earn. So that's not going to be an adequate answer.
So I had a question. So there was some recent Michigan Supreme Court case law, and since the probation has terminated, I don't understand what jurisdiction this court has.
It's actually quite the opposite. The Michigan court has determined that in order for you not to have to stay on probation until it's paid, that we retain authority to collect the money after probation. The alternative would be, which they decided they don't want to do, is keep people on probation until the money's paid. So I retain jurisdiction to collect the money. That's my jurisdiction.
That Your Honor, that's not a jurisdiction. I was off probation. That only applies to if I have an ability to pay, which I don't.
Yes, and I'm
It not only is jurisdiction, but it's her call. That carries the day, my friend. Shut your hole. You don't like that? Take her up on appeal. You will lose. I assure you.
telling you I'm adjourning this 30 days for you to provide proof to the court in person of your assets.
Your Honor, I can't go. I don't have a vehicle, Your Honor. I'm not going to be in person. I'm not going to be in person. I have to take care of my child. I don't have a vehicle.
You will come in person, or you will have a bench warrant. That's how this
fine,
works.
Your Honor. I don't have a way up there. I don't have a vehicle. I have not had a vehicle since November.
Well, I'm going to go ahead and schedule this, and you'll make your choice. If you're not here,
That's
I'll
fine,
issue
Your
a
Honor.
bench warrant. This is set for July 29th.
I'm not
at
showing up in
11.
person. I don't have the ability. What email address to send my paperwork to? This is why there's Zoom.
Okay, they can issue a bench warrant, then you can get picked up, and then the state can take care of your child, apparently. So that's the choice you're making right now. Go ahead there, William.
No, so Zoom is in my discretion. And so I do not have to allow a hearing to occur in Zoom. If you want to email records to the court, you can do that. It's Judge Buchanan Courtroom at lansingmi.gov, and I will review whatever documents you submit. But I'm still scheduling this for an in-person proceeding July 29 at 11.
Here, let me get it before we cut out.
By the way, she would have stuck with Zoom if you weren't an a-hole. Just saying.
Judge Buchanan Courtroom.
At Lansing, MI, as in Michigan, MI.gov.
LansingMI.gov. Okay.
Correct.
So,
okay. And we'll mail you a notice for that July 29th date. You're all set for today.
Have a good day, Aaron. Bye.
Your world frightens and confuses me. My primitive mind can't grasp these concepts.
Is it author triplet? Yes. Yes. You've now picked up a new case. What's the one thing I asked you not to do? You are now charged with violation of a protective order. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
Lieutenant June, an officer observed an operator of a motor vehicle failing to stop at the designated stopping point on a public roadway and initiated a traffic stop. The officer asked for identification. The complainant stated that she did not have any. However, she was identified by her name and date of birth. The officer noticed that the passenger did not have their seatbelt on and requested identification from that individual as well. However, he did not have him as a person and was identified by his name and date of birth. An TCIC search was conducted on this individual, and it notified the officer that the passenger was out on bond. Part of those bond conditions were to have no contact or to be around the CW, placing him in violation of the bond conditions. And those bond conditions were placed, I believe, out of this court judge on April 22nd.
No means no. That's it. I'm going to tell you now that I'm putting conditions on your bond. You know, I am extremely upset with you, Mr. Triplett. You have a prior assault against this person from 22. You have a new assault against this person now, and now you picked up a violation of protective order. The Texas Constitution does not allow me, but in extremely limited circumstances, to hold someone zero bond. Zero bond. This is now one of those situations. I'm putting conditions on your bond. And if you think I'm joking, toy with me. Because now, with what you're charged with, you violate conditions. I can have a hearing to hold you at no bond. And I will do it in a heartbeat to protect every single person in this town. Do you understand? As it stands now, they gave you yet another PR bond. No, goes with you.
Judge, I would like to read, we do have a
And I'm warning you now. No contact means no contact of any kind. You will now be signing another protective order and another condition that will remain through the entirety of this case, that you will not have any contact with the complaining witness in this case. Stop. Do you understand? And if you violate it, again, forewarned is fair warned. Zero bond. I will set a bond for you now. I don't believe your mouthwash story for 1 second. It's insulting that you would even say that, because I told you here the last time when you were admonished the first time, no alcohol from any source, tequila, lollipops, hair dye, isopropyl alcohol. I've heard it all, and it's no alcohol means no alcohol. And if you continue to drink, Mr. Hicks, it tells me that you have a problem. That's what it tells me. Is this the first or second violation?
This is the first violation. First one I read.
Is it a first or a second? You will now be required to do AA classes 3 times a week and bring proof to me that you're doing it. You understand?
Yes, sir.
If you fail to do AA classes and bring it to me on a weekly basis, I will put you in jail. You will not get any more PR bonds, Mr. Hicks. You can get it to your lawyer can get it to me, but I'm telling you, you're skirting an extremely thin line. If that line cracks, your butt's going to go into the ice cold water and it's going to freeze. You understand?
Yes, sir.
No alcohol from any source. And I hope on everything that's holy in your life that you're not driving. Because if you do, I will sprout horns and a tail because I'll be so. You understand me?
Yes, sir.
I have a guy yesterday that we will have a contempt hearing on because he was driving when I told him not to drive. Don't do it.
Yes, sir.
You understand?
Yes, sir.
All right. So he's now required to do AA classes on a weekly basis. He has to get it to you. You can get it to me, and then we'll go from there.
Your Honor, yes, Judge. Can I do that in my county?
Sure. I don't care where you do it. You can do it in Abu Dhabi. I don't care where you do it as long as it gets done and it's done 3 times a week and it's from a legitimate source.
Yes,
You can do it online, but I'm not going to take your word for it. I need proof with a sheet of paper where you did it, the time.
I don't know. I'm not buying the Abu Dhabi AA chapter. I'm just not.
Who the sponsor was so that we can verify, because I'm going to verify, just so you know. All right. Okay. Any more violations? I don't care where it's from. You will stay with me, and I'm going to put you in a treatment facility because it tells me that you have a problem.
Yes.
Yes. All right.
Thank you. Thank you.
How's jail?
Not great.
Really?
Yes, sir.
Over and over and over. And you know that in the last 3 years, you and I have had 12 cases together. Never have you once appeared on your own. You pick up a new case, you plead guilty, you get out, and you pick up a new case. Over and over and over. Miss Washington, I'm done. I will not take any more deals with you ever again.
Okay.
And now I'm going to set your case for trial. And if you're found guilty, we will be looking at a residential facility a dual diagnosis residential facility. I'm telling you now, the days of you picking up a case, sitting there, pleading guilty, getting out and picking up a new case, it's over. Never again. You understand? I'm now, every single time, I guess we'll have to set up a trial and we will start doing the facility approach until it actually takes. But the cycle of you picking up, pleading, getting out and picking up a new case, it's over.
You give me another chance.
Ha!
Please.
Because we haven't given you 25 other chances, Miss Washington. You've never once.
Because I never had a ride and nobody never wanted to bring me to court. So please, Judge, please, I'm gonna never do better.
Do you really think that if I let you out now, you are actually going to come back?
I won't. I promise, Judge. Just one more chance, please. Just trust me, please.
No, that time is long gone, Miss Washington. What I'm trying to tell you is that I want this to stop happening. I want you to stop picking up cases, pleading guilty, getting out, and a week later you pick up a new case. Okay? Well, that's the point. We are now done. It will not happen again. So that next time, because you won't be with us forever, but I want you to think in the back of your mind, the next time you want to make a move when you're in the free world, it's always will end up in a residential facility. Do you understand? Over. Thank you.
So what I have to do now?
We're going to set up a trial and we'll go from there.
What trial?
You're gonna go to trial, we're gonna pick a jury.
If you're found guilty.
Guilty with what?
Well, now you're with us.
Oh.
So your charges against you.
Stealing $20.
I'll talk about the facts of the case.
Ms. Washington, you're charged with harassment of a public servant in your felony case. And with us, burglary of a motor vehicle and a criminal trespass. I have your bond at 7503 on the trespass because you've.
And yet she she admits to yet a different offense.
Never once appeared. And in the other 12 cases that we have, you've never once appeared. So hey, if you were the judge and you saw that person, would you give them a bond?
How long trial is?
You don't know what trial is?
No.
Okay, that's okay. And I'm going to have Greg explain it to you so that we're all on the same page. It takes time to get evidence, but I'm going to try to get it as fast as we can so you don't just sit there and languish.
I can tell you that I did steal the $20.
Stop. I don't want you to talk about the case. The only thing I want you to understand, the days of you pleading guilty, getting out and picking up a new case, it's done. That's it. All right. Ms. Washington. Thank you.
You can make your note if you want.
I'm going to make the note.
Colin. So in January of this year, you picked up a felony theft.
Oh, this is infuriating. This appearance.
In March of this year, you picked up a failure to identify oneself, right? We let you out. You're out in the free world. And now, as of June 3rd, 2024, you picked up another felony theft. Can you please tell me what happened on that one?
Yes, sir. On February 17th of 24 in Harris County, Texas, the plaintiff observed on surveillance Ms. Franks and another defendant stealing bundles of copper wire equipment from a telecommunication tower, loading it onto a vehicle. Individuals observed the photographs taken from the surveillance footage and recognized the defendant. And officers also recognized the defendant by name and sight from other investigations. The property stolen was valued at $7,600.
And again, that was
I heard that it says it was from February.
Yes, Judge,
right?
this was filed as a 2B, so the file date was on June 3rd, while the offense date was February 17th, while the investigation was underway. So it did happen prior to the instant case.
So where do we go from here to ensure that she doesn't pick up any more case?
She did a PR bond, Judge Jones did a PR bond for her. And so we're.
How is it that she keeps getting PR bonds with all these theft cases?
I think there's extenuating circumstances with her health. She has stage 4 cancer and has regular treatments that can't be done in the jail.
Yet, stage 4, all this, and yet she continues to pick up criminal cases. As if the cancer is a good excuse to continue to pick up criminal cases, Ms. Frank. What do we need to do to ensure that you don't pick up a 4th case? Don't give me this sad sob story. I'm not believing it anymore. You came in here hooting and hollering last time.
No, I'm not the person that I was with. Kidnapped me, and I was very abusive.
Really? They kidnapped you?
Yes, he did. He stabbed me, and now I'm able to live with my mother, and I don't have any contact with him at all. He's incarcerated, and I'm safe from him.
Do you know who the complainant, or do you know who this person is?
I do, Judge.
Tell me.
I'm looking into that from on the street. Were you just after the name, Judge?
Yeah, and are they truly incarcerated? And do you know?
He's currently in jail, Judge. His name is Jeffrey Gunn.
Okay.
Yes, Judge.
Here in Harris County?
Yes, Judge.
Okay. So I am ordering you now, Ms. Franks, as a condition of your bond, not to have any contact with this person. I'm ordering you not to consume drugs or alcohol. I'm going to randomly test you. If I find that you're using any alcohol or dope, I'm going to put you in jail. And I'm going to tell you now, you pick up a 4th case, I'm going to freaking lose it. There's absolutely no excuse for you to pick up anything else. The prior felony theft, what's that one about as well?
It's the same thing, the copper wiring.
Is that all? Is it over and over?
So we're to believe that she was kidnapped and taken on a crime spree. I don't buy it for 1 second. It actually makes her health claims suspect in my eyes. Not that I know. I'm not there. I haven't seen the records. That may or may not be the case, but it puts everything into question for me. I was kidnapped and made to go steal copper wire. No, you weren't. You chose to hang out with this guy. You know him. You knew what the deal was, and you did it. It disgusts me. It really does.
Over, she's trying to
That's
get
what.
copper wire.
Pending.
Well, it's
January 14th.
There's currently one pending, Judge, from January 14th, which is a shoplifting theft from a Walmart.
Okay, so that's what I was getting at. So the other one is a Walmart theft.
Do you know? Were you there? I don't know if he stabbed her or not. If that's in the report, it's possible that he stabbed her. But if he did, she knew it. She knew his character. She knew he was the thief. She knew he was violent, and she chose to be there. She wanted to. She's not a victim. It's annoying.
And then there is a conviction, which was produced from a state jail felony for theft of wire.
Okay, so you have an agreement on the cases upstairs, Diana, or no?
We haven't even discussed an agreement yet. We just got her a bond today on the weekend.
Are you going to represent her in this one as well? Okay.
And Judge, I just filed a motion to withdraw and with Dana just now.
Okay, Ms. Frank, the only other thing I'm going to order you to do is don't go back to Walmart. Do you understand? Don't.
It still made me crazy. But it's funny now that you say that.
Hang around this person. Don't go to Walmart. Don't pick up any new cases. The only thing that you should be doing at this point is concentrating on your health and nothing else. If in fact, because I don't know if you do or not. If you pick up a new case, holy moly. I mean, I'm not going to do anything with the bond because she picked up the case prior to our failure to ID. So,
We're set on August 6th. Do you want me to?
August
6th. It's a brand new case. I don't think it's going to be resolved on August 6th, but I mean, that's our next setting.
Okay. I don't want to do out that part just because I want to make sure that she's doing well.
Okay.
Okay. Let's do, 45 days.
Okay.
Come back. We'll see. Hopefully she's been behaving herself. And then, ma'am, do not leave until you sign our bond conditions about not going to Walmart or, and would you mind filing that as well, please? Mind filing, no Walmart,
No Walmart.
no hanging out with homeboy, and no weapons.
Okay, so I will tell you guys all the truth. Not that it matters, but here's the deal. I've had too many court appearances this week, and it puts me in that mood. That's what the practice of actual law will do to you. No patience left.
No random.
Thanks.
Thank God.
Oh, yeah. Yeah. Don't worry about it because I'm going to monitor her just to make sure. Yeah. Okay. 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 This is Jackson.
First name Amaya.
Good morning, Ms. Jackson. Ma'am, you're charged with 2 cases. You're charged with prostitution. You're also charged with failure to identify oneself to a peace officer as a fugitive from justice. Because of that, it kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. So you were stuck. You can't get out. That sucks. I'm really sorry, because had you shown up, good things would have probably happened. You don't have anyone in your life that's able to post a Montgomery bond? Who you here with in life?
Maybe my mom's family knows.
Have you tried to reach out to your mom?
Yes, a couple of times.
What happened?
She married someone.
Do we know if she has a lawyer up there or no?
I don't know, Judge. I'm not sure.
This really sucks. It really does. Because now you're going to end up with at least one conviction. Which one is she pleading to?
Prostitution, Judge. They're going to dismiss the failure charges. So, not sure why.
No, that's fine.
This is what's called a crime of moral. It's a dishonesty crime. It's going to follow you for the rest of your life. But I will make you a deal, ma'am, that if you get out and within 30 days you come back to me, and if you change your mind, we can do something else. After 30 days, though, I don't have jurisdiction anymore. If you really want to get this off your record and you want to do something different, come back to me. We'll try to work something out and we'll try to help you out. But after 30 days, my jurisdiction ends and you will be stuck like Chuck with this conviction on your record. And I'm going to tell you, if you continue to pick these cases up, they will file this as a felony on you because they can use these, if you continue to pick them up, to enhance it to a felony, and then you're looking at years instead of days. What's she being held on? It's a marijuana case, right? All you have is a weed case over there. Once you get out of here, or I'm assuming that they're going to pick her up.
So that I assume so, Judge, as well.
They have 10 days to come get you from Montgomery County. If they don't come get you, Harris County will release you. If that ends up happening, or if you go back to Montgomery County and you're able to take care of your stuff fast, come back here within 30 days and I will try to help you out so you don't end up with a conviction. Do you understand? After that, my hands are tied. You're giving up a lot of rights by entering into this agreement. Ms. Jackson, you're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers, right to be arraigned, charge right to the court, right to remain silent. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this, you can never change this. But I will try to help you out. All you got to do is come back to me here. No probation. She doesn't want probation.
We did discuss that, Judge, but given the old Montgomery County, I don't know that we can, she might still be in the same boat. I don't know how long they'll hold her before she, if she'll get a bond there. I'm not sure without knowing that part of it, Judge, I didn't feel right advising her about that.
Within 30 days, I could reopen this case. If you care enough from that. Ms. Jackson, how do you plead to this case? Guilty or not guilty? No, we'll find you guilty. What is it?
6.
It's 6 days in jail. I will give you credit for the 6 days that you've done. Do we know if Montgomery County is going to pick her up? Have they said?
They don't know yet until
This is done? Okay. All right, ma'am, I'll roll your court costs so you won't owe anything. Come back. Okay.
I'll keep tabs on her, Judge.
Do you have a card to give?
I'll give her one right now.
Call him when you get out, when you're done with Montgomery County, so that he can help you out. Okay? All right, man. Best of luck to you.
Thank you, Your Honor.
Thank you, JP.
All right, so this is a citation. It was issued on May 13th of this year on 20th Street there in Hopkins Township. It's a speeding citation on an actual 70 and a 55. However, it was only written as a 1 to 5 over. So, Ms. Malter, you're here on a speeding ticket 1 to 5 over to do one of three things. First is you could admit responsibility to the citation, or two, you could admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened, or three, you wish to contest this citation. In other words, fight this ticket at what we call informal hearing. What were you looking to do?
I believe I would like to fight the ticket. I don't think the ticket was deserved.
All right. Then even though I cannot see you, I'd ask you to raise your right hand. Same way the officer is raising his right hand. Do you swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Yes, sir.
All right, Ms. Malter, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why you were issued this citation, but then after that, you'll have an opportunity to either ask questions or testify on your own behalf, okay?
Yes, sir.
And with that, Deputy Miller, you want to pick up the narrative somewhere where it makes sense and explain the issuing of this citation.
Thank you, Your Honor. As indicated on May 13th, 2024 at approximately 6:20 a.m. while working as a certified peace officer for the County Sheriff's Department Traffic Division, I was working stationary traffic enforcement on 20th Street near 126th Avenue. It was at this time that I observed a vehicle traveling northbound at a high rate of speed. I then activated my radar in the front antenna stationary mode and obtained a clocking of 70 mile per hour. Furthermore, as I continued to track the vehicle, the driver dynamited their brakes, in which the vehicle slowed down to 60. It was at this time I then initiated a traffic stop, identified the driver as Katie Sue Moulter, who's present here today. Speaking with Katie, she stated that she was on her way to work and that she was in a hurry. Furthermore, Katie indicated that she was trying to get there on time. She knew she was speeding, however, no speed was given. Upon speaking with Katie, she indicated that she did not wish to be cited because she would lose her CDL. As a result of this incident, I did issue Katie citation number SD 28607 for speed. However, I did reduce it substantially off the actual clocking and only issued her a 60 and a 55. I'm a certified radar operator with the Michigan Speed Task Force. My radar was verified before and after my shift in proper working order. There was no objects or hindrances that would have thrown off the radar reading. I have nothing further at this time, Your Honor.
All right, Ms. Moulter, what is it you'd like to tell me?
Well, when I got pulled over, I was coming down a hill, and I just picked up speed due to the hill. And I was actually braking, which the officer couldn't see because he was not behind me at the time. I was trying to correct my speed. And I never once told him I was in a hurry. He asked me where I was going, and I told him where.
You're trying to correct your speed because you were, first of all, I don't believe it, but based upon your testimony, you're trying to correct your speed implies that you're speeding.
He asked me where I worked. So that right there is a lie as well. I did tell him, come on, do you really have to give me a ticket? Because I was coming down a hill and I was trying to decrease speed that I picked up from the hill. And also because I have an excellent driving record. I do have a CDL. I haven't had any speeding citations of the sort in over 20 years. So I don't think there was reason enough to jeopardize my financial future, my career, and, my driving history over something such minor that I was correcting at the time.
Okay, anything further?
No.
All right. Well, ma'am, yes, the information I have in front of me here is that you were clocked at going 70 and a 55. I have, you yourself didn't even present any defense of what speed you were going other than that. So the only information I have is that a deputy telling me he's using a radar that's in proper working order that day that he's certified to use had you at 70 and a 55. He only wrote you for going 1 to 5 over. But it seems that even by your own admissions, you would be going 1 to 5 over. So
I don't know what my speed was. I don't know what it was.
Ma'am. So I have to pick. I have an officer saying you're going 70, and you're saying I don't know how fast I'm going.
Your officer is also. You can tell by the ticket. You can tell by the ticket that he's a liar. Was I going 70 or was I going 1 to 5 over?
No, ma'am.
You can tell that he's a liar.
Ma'am. You were going
What?
70 miles over. That's what all the evidence points to. He used his discretion to try to give you a break and didn't write you a ticket for going 15 over, which he could have written you, and I would have found you responsible.
I don't know. I don't know that I was going
15 over. Well,
I don't know that I was.
Man, you have no idea how fast you're going. It's my turn to talk now. I would find you responsible on this. You would have a right to appeal. You would have to do that within 7 days today's date. You would have to come in and post a cash bond. We are all set. I'm going to go ahead and release parties. Thank you.
Thank you, Your Honor.
Wait for it.
Whatever.
All set. Thank you.
Thank you, Your Honor.
Ah, yes, we end with a nice Karen over in Judge Norbeck's room. I thought that was a nice ender. I need to thank Rocky as usual and Alyssa for hooking me up with clips. It took some going through Judge Fleischer's call. There was a lot more in there. There were some more good moments, but there's lots of dead space too. I did actual editing. I want a brownie. All right. Thank y'all for coming out. I will see y'all soon.